Quentin, good to see you. What can I do for you today?
Hi, thanks for making time to see me again. It's really just a follow-up to the advice you gave me regarding how to enforce our unregistered IP rights. Obviously, having these rights was important, as they meant that strongly worded letters were enough to get a change in behaviour by those who were infringing our rights. It's brought it home to me how important commercially it is to stand up for yourself when your IP rights are being infringed, as otherwise rivals get a commercial boost which they really haven't earned.
Yes, that's right. And the real advantage of unregistered IP rights is that they give a certain amount of protection even without taking steps to secure them. So they arise as soon as something worthy of protection is created, or even earlier if it's part of a process.
Yes, they've been really useful. I was wondering, though, what are the advantages of registered IP rights, and should we be applying for registration of them?
Well, it depends on the nature of the particular IP right. However, for each of them, there exists a public register, which at the very least operates as a way of warning people who may unintentionally infringe your rights that they shouldn't do so. An example would be patents. If I invent something and protect it by the way of registering a patent, then my patent will appear on a public register. If someone intends to try and invent something which is similar, they are deemed to have notice that my invention exists due to being on the public register. If they don't want to waste their time inventing something which has already been invented, they'll check the register to see what's on it. Similarly, I could register a trademark or design, and the same would be true. My item would appear on the public register to warn people as to its existence.
That's a good point. I suppose some people don't so much intend to infringe IP rights, but it's easy to do so if you're not aware of the rights people have. So, a register makes it clear that you have a right.
That's right. The other thing which is typical of registered rights is they tend to be monopolistic in nature. In other words, as there is a public register which acts as deemed notice to the outside world, it is felt appropriate for the right which is granted to the right holder to be very strong. Take patents again. If I have a patent, you cannot produce the item covered by my patent even if you don't bother to look at the public register. You may not actually know about my patent, but it doesn't stop it being an infringement if you produce the item. Typically, this is not the case with unregistered rights, such as copyright. If you write the same work that I have copyright over, it would be a defence that you did so unwittingly, i.e., you wrote it independently of me and without actual knowledge of my work.
That might be difficult to believe, I suppose.
That's right. I say it's a defence, but it might be that a court would not believe that I really did create the work independently. The circumstances may mean that evidentially it's hard for the court to believe that I did anything other than copy. An example would be if you wrote a book. If I write the same book, then it's unlikely to be done without copying. However, who says I've copied off you? The lack of a public register means that I may argue that you copied off me. That brings me to another characteristic of registered rights. You tend not to have to prove the existence of the right, which is not the case with unregistered rights. If I have a trademark, the existence of it on the public register is prima facie evidence that I have the registration. If I think I have passing off rights, however, I have to convince the court that I have those rights before they will enforce them.
I see. So, registration warns off others and usually leads to a stronger right.
That's right. And the right can be longer. Sometimes unregistered rights are time-limited, but registration leads to much longer protection.
I'm beginning to think that we've not taken IP rights seriously enough in the past, as we have no registrations. What I'd like to do, if I may, is make a comprehensive list of things which we'd be annoyed if others tried to use or rip off. And then perhaps you could advise us as to the steps required, likely time frame and costs, etc., to gain protection, together with the specific advantages of the relevant rights. Would that be something you could do for us?
Of course. I'll let you know the pros and cons of registration for each item. It may be that for some items, unregistered protection is sufficient. At the end of the process, hopefully it'll help you decide whether you want to instruct me to gain registrations for you. They're not always cheap, so it's not just a question of saying always register. It's a question of judging the pros and cons in each case.
Great. Well, I'll make a list and get it to you in the next day or so, and we'll progress it from there.
That's fine, Quentin. Good to see you again, and I'll speak to you after I receive your note.